Why is it so hard to win an EB-1A Extraordinary Ability petition? Hi, my name is Audra Doyle, and I'm the owner and attorney of Doyle Law here in Atlanta, Georgia. And over the years, my firm and I have filed many of these petitions, and most of them have been approved. But today's video is going to talk about the trends that we're seeing, and we're going to especially discuss why it is so hard these days to get your case approved. So this all really started to be tougher and tougher around 2012 during the Obama administration. We started to notice more difficult adjudications, and then we had a court case come out which was very surprising. It's called the Kazarian decision. And if you are in this world of extraordinary ability cases, you might be familiar with that decision. Now, previous to the Kazarian decision, we had a case called Bulletini versus INS, and it basically instructed the service if a person has met 3 of the 10 criteria, then they are presumed to have extraordinary ability, etc., etc. Case should be approved. But in Kazarian, there was some dicta from the court that discussed a final merits determination. And I was so surprised that I shouldn't have been, that the Immigration Service decided to follow the Kazarian dicta, which isn't even part of the decision. It's just a little footnote in the case that says final merits determination. Well, the Immigration Service has grabbed onto that and they have run with it as far as they can. So now instead of meet 3 criteria, you're qualified, it is meet 3 criteria and meet the final merits evaluation that they do for these cases now. So that is the first thing that has changed over the years of why it is more difficult to win these cases, because meeting 3 criteria, that is objective. You either do or you don't. You either have publications, you have judged the work of others, or you have not. On the other hand, with the final merits determination, it is a subjective test. And the way I describe that to my clients is that we have to give immigration a good feeling about your case, which can be very difficult to do. We have to impress them enough and demonstrate that you have reached the very top of your field with sustained national or international acclaim. And I've noticed since 2012, every year, and even every month, it could be that we have to add more and more information to the cases. So for instance, it was sustained national or international acclaim. And then a few years later, I discovered that I was getting pushback about what is the potential employee or what is the potential applicant going to be doing in the United States? How are they going to substantially prospectively benefit the United States? So each time we see immigration pushing back on a particular phrase or a particular part of the regulations, I take that information and I use it for my next cases. So in that situation, prospectively benefit, now we write a personal statement and the client has to explain what they are going to do in the United States that will benefit the United States. So again and again, more and more requirements have started to come in. And then after we do all of this work, hours and hours of work, that we file the case, and it is very possible we're going to get a request for evidence. When you premium process a case, in my opinion, the chances go even higher that you will get a request for evidence, and immigration is going to push back hard. I've even had them push back on whether or not an article is a scholarly article. Like, that is the level of detail and the level of pushback that I receive from the service. But so the next thing I want you to know is that you have to be prepared to fight. If you have an easy, smooth sailing EB-1 case, that's great. But the majority of applicants are going to get pushback from the service. They may get a difficult request for evidence. They may even be denied by immigration. But I don't want you to think that your case is not approvable. When a lawyer like me or other lawyers, we evaluate your case, I am not going to take on a case that I do not think is approvable. So you should set your mindset there. Audra, my lawyer, or whoever your lawyer is, they think that my case is approvable. Generally, I will give a percentage of chances of how good a chance I think you have of winning. And the types of denials that we're seeing from immigration are just really outrageous at this point. And so over the past 3 or 4 years, lawyers have had to resort to extreme measures. Never had to do it before, but these days, if a case is denied, we seriously consider taking that case to court and filing a lawsuit in federal court asking a federal judge to evaluate whether the service has properly adjudicated the application. And many times the court will overturn the decision, or the court will say, immigration, you failed to do your job. This is an arbitrary and capricious decision. You failed to review all the evidence and you need to go back and redo this case. So we have recently had that in one of our cases. A leader in the field, top of the line, everything was wonderful, got denied. We took it to court, it was overturned, we got another difficult request for evidence, and now the case is approved. So I want you to understand, even though there's a lot of pushback from immigration, we have to really fight on these cases. The fight is worth it, and these cases can be approved. Now, in the future, I hope that there is some sort of legislation or some sort of policy change from the Immigration Service. But in the meantime, those are some reasons why we're seeing the difficulty of getting these cases approved. And I want you to understand you're not alone. Many people have to fight very hard for these extraordinary ability approval cases, but it can be done. Please click the subscribe button here on YouTube and also the bell so that you're going to get updates when I post new videos. And if you have any questions, let me know.